Good morning, everyone. Thank you very much for joining us today for our talk on restrictive covenants. My name is Ellie Crofts and I'm a Senior Associate in the Property Disputes team here at Lodders. My fellow speakers are Jane Senior, who is the Head of Dispute Resolution, and Vicky Khandker, who is the Head of Property Disputes. We have a team of 7 specialist property litigators here at Lodders, and we cover all aspects of property disputes, including landlord and tenant, commercial matters, real estate disputes, and residential property issues. We're going to talk today for around 45 minutes, covering various topics relating to restrictive covenants. I'll be starting us off by looking at the characteristics of restrictive covenants, comparing them with positive covenants, and also looking at the requirements for a restrictive covenant to be enforceable. After that, Jane will talk about building schemes and the interpretation of restrictive covenants. Vicky will then cover modification and discharge of restrictive covenants, and then I will briefly cover the principal remedies for breach. After we finish speaking, we'd be happy to take any questions, so please do pop any questions you've got in the chat box at the bottom of the screen, and we'll deal with those at the end of the session. So, to start us off, what exactly is a restrictive covenant? It's essentially an agreement that one party will restrict the use of its land in some way for the benefit of another person's land. For example, limiting the use of land for residential use only, or restricting the number of buildings that can be erected, or prohibiting certain trades or businesses being run from the land. Restrictive or negative covenants are contrasted with positive covenants, which impose an obligation on one party to do something or to expend money. For example, a positive covenant can require one party to maintain a boundary fence. The principal difference between positive and restrictive covenants is that restrictive covenants run with the land and therefore are generally binding on successors in title, subject to certain requirements, which I'll look at in more detail shortly. Positive covenants, on the other hand, don't generally bind successors in title, and the purchaser of land burdened by a positive covenant will usually be required to enter into a separate deed with the owner of the benefiting land, so that positive covenant will continue to be binding. So how do we tell if a covenant is positive or negative? Usually it's clear from the wording of the covenant. A restrictive covenant may say not to use the property for more than one residential dwelling house. A positive covenant may say to erect and maintain a boundary fence at least 1 metre high. However, where it's unclear, the meaning and effect of the covenant must be carefully considered to ensure whether it's positive or negative in nature. For example, the leading case of Tulk and Moxey, the case involved a covenant which stated, which is on your screens, keep and maintain a piece of ground and square garden and the iron railing round the same in its then form and in sufficient and proper repair as a square garden and pleasure ground in an open state, uncovered with any buildings in neat and ornamental order. So on your screens, there's going to just be a quick poll. I would like to see how many people think that this is a positive covenant and how many think that this is a negative covenant.
The result is 69% say positive and 31% say restrictive.
Thank you very much, Angela. So most people think this is a positive covenant, and on first reading, it would be a positive covenant. It's requiring the burdened party to maintain a parcel of land as a garden. However, the court actually construed it as amounting to a negative obligation not to build on the land. Conversely, a covenant that not to allow property to fall into disrepair, although expressed as a negative in a negative manner, is actually positive in nature as it requires expenditure of money on repairs. So now we're clear on what a restrictive covenant is, let's turn now to the enforceability of such covenants. All restrictive covenants are enforceable as between the original parties as a matter of contract law, but many restrictive covenants that we encounter today are often years or even decades old. And the question that arises is whether the covenants are enforceable by and against the party's successors in title. Generally, the benefit of a restrictive covenant automatically passes to successors in title at common law, but the burden doesn't. Therefore, there are several preconditions that have to be met for successors entitled to the original parties to enforce the burden of a restrictive covenant. Now, broadly, these requirements are that the covenant must be genuinely restrictive in nature, the covenant must be correctly registered, the burden of the covenant must have been intended to run with the land, the covenant must touch and concern the land, The beneficiary of the covenant must actually own the benefiting land. The covenant must be clear and unambiguous. The benefiting and burdened lands must have been in separate ownership at all times. And the benefiting owner must demonstrate the benefit of the covenant has been properly passed by annexation, assignment, or a scheme of development. So let's go through what all that means. Looking firstly at the covenant must be genuinely restrictive in nature. Only negative covenants are enforceable in equity against successors in title. As I mentioned earlier, positive covenants don't generally bind successors in title, and the beneficiary of a positive covenant will have to ensure that any purchase of the burden land enters into an express deed. The covenant must be correctly registered. In order for it to be enforceable against successors in title, future purchasers of the burdened land must be aware of the covenant's existence. With registered land, this means that the covenant is registered against the burdened land's title. With unregistered land, the deeds or epitome of title must contain reference to the covenant. In the case of covenants created on or after the 1st of January 1926, which is when the 1925 Law of Property Act came into force, restrictive covenants should be registered as D2 land charges. A covenant that is registered as a land charge is deemed to constitute actual notice on the buyer of the burdened land, whether or not their solicitor actually carried out a land charges search. The next requirement is the burden was intended to run with the land. The covenant must not just be a personal covenant between the original parties. Section 79 of the Law of Property Act states that restrictive covenants are treated as being given on behalf of the original covenantor, its successors in title, and those deriving title under the covenantor, unless a contrary intention is expressed. The burden of a restrictive covenant is therefore assumed to be intended to run with the land, unless the contrary is shown. With restrictive covenants entered into before the 1st of January 1926, the issue depends on the construction of the particular wording used and the nature of the obligation contained in the covenant. The wording of older covenants should therefore be checked to see if it was the intention that the covenant should bind successors in title. The covenant must touch and concern the land. Now, this means it must affect the land, benefit the owner of the land for the time being, and not merely be of personal benefit to the original contracting party. The covenant must affect the nature, quality, user, or value of the land, and must not be expressed to be personal. The covenant should actually benefit or preserve the value of the land, for example, preserving the character of the property or the neighbourhood. If the covenant merely secures an obligation to pay money, rather than genuinely protecting or preserving the amenity or value of the benefiting owner's land, it won't be enforceable as a restrictive covenant, and it won't bind successors in title. In the 2013 case of Cosmicombe and Southampton City Council, what happened here, the council sold a building in 1989 to the BBC, and it was to be used as a regional broadcasting centre. The transfer contained a restrictive covenant which prevented the property from being occupied by anyone other than the BBC for the purpose of a broadcasting centre. But the covenant was subject to a proviso that it could be removed by the written agreement of the council and payment of a development sum comprising 50% of the increase in value of the land following a change of use. The BBC sold the property to Cosmicombe in 2004, and Cosmicombe issued proceedings seeking a determination that the covenant was not enforceable against successors in title of the BBC. The court agreed. The court felt that the covenant didn't benefit the council's adjoining land when it was imposed. It didn't benefit that land now, and the reason for imposing the covenant was purely to secure a financial advantage should the BBC ever cease to occupy that land. It was therefore not a restrictive covenant which would bind the BBC's successors in title. The next requirement is the beneficiary of the covenant must actually own the benefiting land. And this does make sense. The person seeking to enforce the covenant must own the land or have some interest in it that's recognised in equity. For example, a person who's contracted to purchase the freehold or is a beneficiary under a will. Excuse me. The covenant won't be enforceable except against the original owner of the burden land if the person seeking to enforce it no longer owns the benefiting land. The covenant must be clear and unambiguous. So this requirement needs the purpose and intention of the covenant should be clear from the wording of it. In the case of Queen Elizabeth Grammar School and Banks Wilson, The restrictive covenant here prohibited new constructions above the height of the existing buildings, but it wasn't clear what that meant. Did it mean the roof line? Did it mean the line of the chimney tops, or did it mean something else? And because it wasn't able to be ascertained exactly what it was meant, the covenant was unenforceable for ambiguity. The benefiting and burden lands must have been in separate ownership at all times. If the land benefiting from the covenant and the burden land have been in common ownership since the covenant was imposed, even if at the time of enforcement they're in different ownership, the covenant will be unenforceable. The benefit of the covenant must have passed to the person who was seeking to enforce it, either by annexation, assignment, or a scheme of development. Now, for the majority of covenants created after 1925, the covenant is likely to be annexed to the land pursuant to Section 78 of the Law of Property Act 1925, and I've put the wording of that section up on the slide. Under this section, a covenant is deemed to be made with the benefiting owners, successors in title, and persons deriving title under them. Successors in title are deemed to include the owners and occupiers of the benefiting land. Providing the benefiting land is identifiable, then most covenants are going to be automatically deemed to be annexed to the relevant land, and you don't need to consider it further. However, if the covenant predates 1926, or the land is not identifiable so as to trigger Section 78, you then need to consider the alternatives. Express annexation must be evident from the wording used or from the construction of the document, taking into account the surrounding circumstances of how the document came into being. The wording must identify the land in question and make it clear that the land was intended to be benefited by the covenant. Common words of annexation include so that the benefit will be annexed to and run with the land, or for the benefit of each and every part of the land. A covenant with Mr. Jones and his heirs, executors, administrators, and assigns without reference to any specific land will be insufficient to prove annexation. If you are able to prove annexation, then the covenant will pass, the benefit of the covenant will pass to successors in title without the need for any further action by the seller or the buyer. If annexation isn't an option, the second option is assignment, whereby the beneficiary of the covenant must show that the benefit was expressly assigned in writing each time the benefiting land was sold. The beneficiary must be able to produce a complete chain of assignments, which are usually included within the conveyance or the transfers of the benefiting land, and expressly state that the benefit of the covenant is to pass to the purchaser. So when you're purchasing land which benefits from a restrictive covenant, it's always important to ensure all the deeds are handed over on completion if the land isn't registered, to make sure you have that chain of assignments. If annexation or assignment aren't applicable, then to enforce a restrictive covenant, the beneficiary must approve a scheme of development. Where a building scheme exists, restrictive covenants may be enforceable as part of a sort of local law by the owners of individual plots and their successors in title. I'm now going to pass over to Jane, who will look at this issue in a bit more detail.
Thank you, Ellie, and good morning, everybody. Yes, so I'm going to start with building schemes, as Ellie says, and what are these? So these are where several properties are sold off, often at the same time or similar time, and the same restrictive covenants are placed on each property. So this is often the case with an estate development, and each of the parties subject to the covenant, as Ellie says, can enforce those covenants directly against the owners of the surrounding properties, rather than relying on the direct beneficiary to do so. A good example of the court looking at building schemes and deciding actually whether there was a building scheme in place at all is this case of Birdlip and Hunter. It was looked at by the Court of Appeal in 2016. And here, the owners of two properties, Ashley and Little Orchard, which are in Gerrard's Cross, were arguing. All of the land around them had been developed at the beginning of the 1900s and had been sold off from one large plot into individual plots. The owner of Little Orchard obtained planning permission to build two houses within its plot of land, And the next door owners of Ashley sought to prevent that, seeking to enforce the restrictive covenants and saying that it was that this was a building scheme and therefore mutually enforceable. When considering whether there was in fact a building scheme and therefore mutually enforceable covenants, the court decided that there are two prerequisites. Firstly, the land subject to the scheme must be clearly identifiable, and the documents, the relevant deeds, indicate really on the face of them what land forms part of the scheme. Secondly, there must have been an acceptance at the time the original covenants were put in place that there would be this arrangement of mutually enforceable covenants. So what did the court find in Birdlip? Well, they found that the area of land affected by the scheme was not obvious because there was no clear plan attached to the original conveyances showing the area of the scheme in question. And so the court found that in fact the owners of Little Orchard were free to proceed because there was no restrictive covenant. So I'm going to look at now how we approach the interpretation of restrictive covenants. And on the screen is an example of a typical covenant that we're asked to look at. So not to erect more than one dwelling house in accordance with plans approved by the agent of the vendor, and not to carry out alterations without consent as aforesaid. So the first question that we would look at is, does the vendor include successors in title? Ellie's talked about the sort of technical requirements to make that happen, but the question is here, was vendor meant to include successors in title? Firstly, we would obviously look and see if there's any definition within the deed which may say vendor includes successors in title. If there is no such definition, then we would look at the rest of the document and see if there are other references to vendor and successors in title. So let's say that there are other restrictive covenants in the same deed, and those covenants talk about the vendor and successors in title, whereas in this covenant it only refers to vendor, then we'd be entitled to conclude that the draftsperson meant what they said, and that it is only the vendor, or here the agent of the vendor, who can approve the plans. And that can obviously cause a problem because the whereabouts of the vendor may not be known, and so that may lead to basically an absolute restriction that can't be got over, and the party who would have liked to get approval can't get it, basically. The next point on this one is the provision of consent that's required. So let's assume that you either can find the vendor or vendor includes successors in title. Does the party with the benefit of the covenant have to respond reasonably? And in short, the answer is yes, they do. So looking now at a case where the interpretation of restrictive covenants was looked at in this context, Crest, Nicholson and McAllister back in 2004. Here, plans had to be submitted for approval to the vendor company, but the company had ceased to exist. So what did the court say about that? Did it mean that approval couldn't be obtained, therefore works could not be done? The court said no, where the company ceased to exist, the draftsperson couldn't possibly have meant that that was it, no works could be done. And so there would be no intention of putting an absolute prohibition. And so it was fine, effectively that covenant was discharged and no consent was required. Another case on similar point, City Inn and 10 Trinity Square. Here, the Port of London Authority were a successor in title, and they wanted to do some works. Vendor's consent was required. Obviously, the vendor was no longer the owner, and the Port of London Authority were arguing that to suggest you had to go back to the original owner rather than the current owner to ask for consent was a commercial absurdity, and it would deprive the covenants of value if it didn't apply to the current owner and to the successors in title. They were trying to say it just makes sense that the parties who currently own or have the next door property, it should be between those two, not people who owned the property ages ago. So what did the court say about that? They disagreed. They said, no, it's not. In this case, it wasn't a commercial absurdity because the original vendor still owned property in the surrounding area and pretty close to Mariner House, which was the property in question. And so they said, no, the vendor's consent is required, and if they're not going to give it, or if they're going to give it, that's the decision that counts. So looking at a different sort of covenant now, this is to do with covenants where use is restricted to single private dwelling houses, and I'm going to do a poll. So you can see on the screen two covenants that often come together: to use a property only as a single private dwelling house and not to carry on a trade or business at the property. Are these covenants breached by short-term lets through, for example, Airbnb or Booking.com, which obviously are often just for a night or a few nights? If you think that both covenants are breached, then the answer will be yes. If you think neither covenant is breached, the answer will be no. You may say, I think it's just the first one that's breached, or you may say it's just the carrying on the trade or business that's breached. So the questions have been brought up, and perhaps you could let me know what you think.
40% say both, 26% say no, they won't be breached, and 28% say the second is breached, and only 6% say the first is breached.
Only 6% say the first is breached?
Yeah.
Yeah, okay. Well, that's very interesting. Thank you, Angela. Basically, this point was looked at in a case, Triple Rose and Beatty, in 2020. It has been looked at in various cases, but the covenant in this Triple Rose case was the one that we've just been looking at. And the judge, Martin Rogers QC, it was in the tribunal, said short-term occupation by paying strangers is the antithesis of occupation as a private dwelling house. So he considered that Airbnb would be a clear breach of the covenant to use as a single private dwelling house. He said occupation by continual string of strangers just isn't going to be private. It lacks the permanence that's required to tick the box of being a dwelling house. And as regards does it breach the covenant about trade or business, he said you've got to distinguish between using premises for a business and carrying on a business at the premises. And Airbnb is using for business, but you're not actually carrying on the business at the premises, which is that latter wording that was in the covenant. So in this case, there was a breach of the first covenant, but no breach of the covenant about using for not carrying on the business at the property. So so basically Airbnb is going to be prohibited in a lot of properties that prevent that require use as a single private dwelling house. So next one which we see a lot is covenants against causing nuisance and annoyance. What does this mean? Well, for a nuisance, it doesn't mean, oh, they're a bloody nuisance. It means it's got to be an actionable nuisance. So perhaps noise nuisance or light nuisance, could be something to do with drainage. It's got to be something where you actually have a cause of action to take to court. Annoyance, however, is wider and is more as a reasonable person would think. So there was a case, Davies and Dennis, which was a property there was a series of properties that were riverside. They all had lovely views of the river, and one of the owners decided that they were going to build such as would obstruct the views of other property owners. So as you can imagine, the other property owners were very annoyed at this this idea, and so sought to restrict it. And the court agreed that the new building shouldn't proceed, because to a reasonable person that would be annoyance. It wouldn't be an actionable nuisance because there is no right to a view, and so you wouldn't be able to prevent it in that way. So it was good that there was this extra wording of annoyance. Basically it's an objective test, and it's how would a reasonable person react. So there's this Todd Heatley case from quite some time ago. There was proposed development of a school building and building on playing fields, and people were seeking to prevent that building, and they said it was a nuisance or an annoyance. But what the court said is here, what the adjoining owners are really concerned about is not the building, but they're concerned about the traffic that will result from this enlarged school, basically. And so the court said that isn't a breach of this covenant, because it's not the actual extra building that's going to cause the problem, it's the consequences of that. And so there was no breach of covenant. So I'm going to hand over now to Vicky, who might have some suggestions for us in terms of people who are facing covenants that might otherwise be restrictive. Vicky.
Thanks, Jane. So I'm going to look at what you can potentially do if you have a covenant that just doesn't work for you and what you want to do. By Section 84 of the Law of Property Act 1925, the upper tribunal has jurisdiction to vary, modify or discharge restrictive covenants over freehold land, and also to modify leasehold covenants where there's a lease with a term of over 40 years with at least 25 years having already passed. Note that this procedure is only for covenants which are truly restrictive. And the tribunal can impose modification, it can impose further restrictions on modification. It doesn't necessarily discharge them entirely. It's also likely that compensation will be payable to any objectors. So just a very brief example of some of the types of clauses that the upper tribunal has been asked to consider. So a clause to not knowingly permit any new window, light, opening, doorway, path, passage or drain or other encroachment or easement to be made or acquired into, against or upon the demised premises. Only to use and occupy the demised premises solely and exclusively as a self-contained residential flat. And to use the demised premises only as a building of the type specified in Class 2 in the schedule to the Town and Country Planning Use Classes Order. And we're going to look at a case on that point. So it's quite a wide selection of covenants that the tribunal can be asked to look at. It's thought that you can't contract out of Section 84 to prevent applications, but there are instances where clauses may be set out which will trigger a payment to a benefiting party if an application is made to modify, and that's considered to be completely valid, although that clause itself might be subject to a Section 84 application to modify it as well. So what are the grounds on which you can make an application? In order to make a successful application, you have to rely on one of the following, at least one of the following grounds. Ground A, that the restriction sought to be modified or discharged has become obsolete because of changes in the neighbourhood since its imposition. Ground AA, that in certain prescribed circumstances, the continued existence thereof would impede some reasonable user of the land for public or private purposes, or would, unless modified, impede such user. Ground B relates to consent having been given by the person with the benefit. And ground C is that the proposed discharge or modification will not injure the persons entitled to the benefit of the restriction. So looking at those grounds in more detail, ground A concerns, can we just flick onto the next slide, please? Ground A is looking at potentially social changes, for example, changing attitudes to the sale of alcohol, or it could be environmental changes. For example, an area is now a mixture of residential and non-residential uses, whereas historically it may have been solely residential. There's two questions to be considered in looking at application to ground A. Firstly, have there been material changes in the character of the land, the neighbourhood, or some other material change since the covenant was imposed? And secondly, looking at what the original purpose of the covenant was and can it still be achieved? If there have been changes, in answer to the first question, should the covenant be deemed obsolete as it can no longer fulfil its original purpose? So for some examples of applications under ground A, where there's been changes in the character of the property. So for example, where the property has been used in breach of covenant for many years as commercial rather than residential premises. Secondly, changes in the character of the neighbourhood. And an example of that was the Broward Estates case, where the area had historically been various large houses in very large plots. The applicant wanted to build additional houses on its site in breach of covenant. As the grounds of the neighbouring houses had just been sold off for building, the covenant was deemed to be obsolete, although it was modified to impose a cap on the number of properties to be built in line with the applicant's plans, in this case to build 4 properties. The tribunal can consider other material changes. So, for example, in Kennet's properties, there were covenants in place to protect the view, but since the covenant had been imposed, the view just was no longer there because other buildings had been constructed, and therefore the covenant was obsolete. In Cox's application, there was a covenant restricting use to occupation by domestic staff for an adjoining house. As times had somewhat changed and domestic staff, live-in domestic staff weren't so common, there was no prospect of the adjoining house ever needing staff to occupy the property. And therefore, in this case, the covenant was deemed to be obsolete, but it was only modified to allow use by agricultural staff instead. And then there's some other examples of cases where it's simply been found there's been no demand for maintaining the covenant. So in the Jerub case, it concerned a sports ground that there was just found to be no demand for. And in Greaves, it concerned allotments. There were numerous examples of applications failing as well, where despite changes in the locality, the covenants were still found to protect the original benefit and therefore were not obsolete. And so every case is going to be very fact specific. So the next ground is ground AA, and I've got the wording of the ground back up on the slide. Now, this is the most common ground, or certainly where the tribunal has focused the most attention. Under section 84(1)(a), the relevant circumstances for bringing an application under ground AA authorises the discharge or modification of a restriction by reference to its impeding some reasonable user of land in any case in which the tribunal is satisfied that the restriction in impeding that user either doesn't secure to the person entitled to the benefit any practical benefits of substantial value or advantage to them, or it's contrary to the public interest, and that money will be adequate compensation for the loss of disadvantage which any person will suffer from the discharge or modification. And you've got to take each of those steps in turn. In determining whether the case is one falling within this section, and in determining whether a restriction ought to be discharged or modified, the tribunal will take into account the development plan and any declared or ascertainable pattern for the grant or refusal of planning permissions in the relevant areas, as well as the period at which and context in which the restriction was created or imposed, and any other material circumstances. So an order discharging or modifying a restriction under this section may direct the applicant to pay consideration assessed by the tribunal as follows. And this applies to all the grounds, in fact. Firstly, a sum to make up for any loss or disadvantage suffered by that person in consequence of the discharge or modification. Or secondly, a sum to make up for any effect which the restriction had at the time when it was imposed in reducing the amount paid for the land subject to the covenant. There's been a number of cases where benefits have been found to include things like views, the character of the area, prevention of flooding, privacy, tranquility. So it's not necessarily something that you would perhaps associate purely in value terms. However, a practical benefit was not found where only money was wanted. And the authority for that is the Tate case in 2013. So I'm going to come on to have a look at a couple of cases on this ground. First of all, I want to briefly look at the Chavaram Normandy case. And I'm not going to go into too much detail because I have actually looked at this in a previous seminar, but it concerned the former IBM headquarters in Basingstoke, as you can see on the slide. Now, this was an application in respect of leasehold covenants. So the freehold was owned by Basingstoke and Dean Borough Council. And there was a head lease to Greytown Investments for 150 years from 1985. The head lease included a covenant restricting the use of the buildings to offices only. And I've put the actual specific covenant on the slide, and there were some other relevant clauses as well. It was sublet to IBM under a lease expiring in December 2014, and IBM were physically in occupation until 2013. But since then, the property had fallen into a significant state of disrepair, which had been accelerated by vandalism, and they were really struggling to let it as offices. So May 2015, the head lease was acquired by Chavaram, and they wanted to convert it into 114 residential flats, which would be let on assured short-hold tenancies at open market rents. The local authority who had the freehold would not agree to Chavaram's request to vary the user covenant. Chavaram therefore made an application to the tribunal to modify the covenant under section 84, and they sought to rely on grounds A, AA and C, but the case largely centred on ground AA. As a slight side note, the local authority had argued that there should be a higher test for long leases than freehold land, because the opposing party in this situation was the owner of the reversion rather than other land, but that argument was ultimately unsuccessful. The main issues between the parties focused on whether the office use restriction in the lease clause secured any practical benefit of substantial value or advantage to the local authority. And they focused most of their arguments around there being an office quarter in Basingstoke, which residential use would water down. The tribunal, on hearing detailed expert evidence, concluded that if the building was refurbished to the agreed specification for office use, the freehold reversion would be worth 3 million and its average annual income would be 160,000. If it was just repaired, the annual income would be 117,000 and the reversion would be worth 1.875 million. And if it was converted to residential, the annual income would be 144,500 and the reversion would be worth 3.125 million. So the office use specification and the residential use didn't actually have very much difference in terms of the value of the reversion. The local authority therefore broadly contended that the benefits that it obtained by virtue of the covenant were firstly the prosperity and economic advantages for the town of retaining office use in preference to residential use, and also the thin end of the wedge argument, i.e. by modifying the covenant were other commercial leases with similar provisions also likely to be able to modify, and therefore it would create a domino effect. Looking at the evidence overall, the tribunal did not accept the local authority's argument that the retention of Normandy House as office space would make a significant contribution to the economic well-being of the town. There was in fact already an established precedent for mixed use in that particular area. Therefore, the tribunal concluded that the retention of the office use restriction did not secure any benefit of substantial value or advantage to the council, and ground AA had been made out. And if we just look, this is Normandy House now developed out into flats. It's important to note that cases like this will always be dealt with on a case-by-case basis, and in other circumstances they may well have failed to make out the ground. Here, if the local authority had had a more consistent and thought-out policy in respect of their office quarter, then they might well have been able to resist the application, and so similar covenants may well be upheld in other circumstances. The next case I want to just touch upon is the Alexander Devine Children's Cancer Trust and Housing Solutions. Here there was a covenant that no building of whatsoever nature shall be built. A developer constructed a social housing development of 23 units on a site called Exchange House in compliance with the Section 106 agreement in relation to the development of another site. Of the 23 units, 13 of them were built on the part of the site burdened by restrictive covenants, which prohibited the land from being used for building at all for any purpose other than a car park. The developer went ahead with the development and physically built out, despite objections from Mr. Smith, who owned part of the land that benefited from the covenants. The remainder of the benefiting land had been donated by Mr. Smith to a children's cancer trust, which began building a hospice to accommodate terminally ill children shortly after the developer had completed its development. The developer, after building, applied to modify ground AA on the basis that the covenant impeded some reasonable user and was contrary to the public interest, because to enforce it would mean that the 13 affordable housing units, which had already been built, would be wasted. The key point to remember in this is that this risk only occurred because the developer had already built those units in breach of the covenants. The upper tribunal initially granted the application on an order for payment of £150,000 compensation to the trust, even though the developer had deliberately and cynically chosen to build in breach of the restrictive covenants and despite being requested not to do so. However, the Court of Appeal subsequently overturned this decision, which was further appealed, but the Supreme Court upheld the Court of Appeal's decision. Crucially here, the developer could have built on the part of the site that was unencumbered by the restrictive covenants, because planning permission would most likely have been granted for that. Furthermore, the developer would have been unlikely to satisfy the public interest ground had it applied to modify the restrictive covenants prior to building in breach of them. By building the houses, the developer had created the situation itself in which it could argue that maintenance of the covenants was contrary to the public interest. The developer shouldn't be rewarded for presenting the tribunal with a fait accompli, and ultimately, therefore, the covenant was not modified. This decision serves as a clear warning to developers of the risks involved in deliberately carrying out a development in breach of a restrictive covenant, even if planning permission has been obtained without any objections. I've not been able to find out what has actually happened since on site, and whether they've come to an arrangement or whether the houses are in fact having to be removed. But the lesson here has to be that an applicant cannot benefit from its own breaches. If there is a covenant over the site, deal with it first before incurring the expense of building. Moving on to the next ground, which is ground B, and I've put the wording of the ground in full on the slide. But note that essentially this is agreement, but agreement can be express or implied. It is more uncommon to make an application on this ground because if there is consent, then it should be capable of being dealt with by a deed of variation or similar. But there are some instances where there might be technical reasons where you might need an actual order of the tribunal, for example, if there's minors who need to be bound. A couple of examples of applications under ground B. The Marcello Developments case concerned land with a covenant to use it only as a single dwelling house, but in fact there had been flats on the land for 50 years, and in that instance that was found to be an implied consent. In the Child Brothers case, the permitted number of houses had already been exceeded on 14 out of 22 plots of land which were bound by the covenants. The tribunal found that this was evidence of the general disregard of the covenants, which meant they would have been impliedly waived. And then in the Robinson and O'Connor's application case, the covenant restricted use of the shop to specified trades for the benefit of adjacent shops. The applicants wanted to modify the restriction to allow use as an off license, which it had been doing for a year already. The beneficiaries of the covenant had written to the applicants confirming that they were willing to consider a modification, but for whatever reason that wasn't then followed up, and the applicants made an application directly to the tribunal. The tribunal found that the correspondence was an irrevocable consent because until a deal had been done it hadn't been concluded, and this wasn't sufficient to constitute implied consent. So the final ground is ground C, and it's almost a little bit of a kind of catch-all and is commonly used with other grounds. So this is where there is no injury to the beneficiaries. So examples of this are to stop vexatious or frivolous objections. And an example of this is Reed Pearson's application, where an application was made to alter a barn and convert it to a nursing home. The objectors claimed that if the application were granted, it would be more difficult for them to obtain planning permission for their own land for industrial purposes. But the tribunal found that they didn't actually have any prospects of success of getting any such permission. And so they suffered no prejudice by the modification. Second common ground is, well, it's the catch-all no injury, but an example of that is Reed Chapman's application, where the application was to build an additional house on the property in breach of covenant. And the tribunal found that the new house would be screened from those with the benefit, and therefore they wouldn't suffer any injury at all because they wouldn't notice it was even there. Another example of ground C is where there's evidence that the covenants are used to extract money alone and not to control the development. And also the thin end of the wedge argument is commonly employed in ground C. And it does need to be considered carefully. That argument cannot just be dismissed. The immediate application might not cause harm, which is why there'll be a ground C application. But it will be commonly be defended on this thin end of the wedge argument because it could impact upon future applications. And although we've looked at a case where that was dismissed, it will be seriously considered and shouldn't just be dismissed. So the final point I just want to touch upon in respect of this is costs of applications to modify and how they are dealt with. And this is contained within the Lands Chamber Practice Direction. By paragraph 1510, unsuccessful objectors will not normally be ordered to pay any of the applicant's costs unless they've acted unreasonably. Because it's the applicant seeking to remove or diminish the property rights of the objector, the tribunal won't usually regard making an objection and pursuing it to a hearing as unreasonable. So just something to bear in mind, that if you make your application, even if there's objections, then the chances are that you're still going to be responsible for all of your costs. It's not quite the same as the loser pays all as it can be in some litigation. Successful objectors, conversely, will usually be awarded their costs unless they have acted unreasonably. And although it uses the word unreasonably in these clauses, in my experience, that's quite a high barrier to get over, and courts are usually quite reluctant to find that someone has behaved completely unreasonably in these circumstances. There are also some specific separate rules relating to where there's a challenge to the objector's entitlement to the benefit of the restriction, and the rules can vary slightly there, but largely it's going to be the position that successful objectors will recover their costs and the applicants are going to be covering all of their own costs. I'm now going to hand over to Ellie to look at some other remedies for breach of covenant.
Thanks, Vicky. So, as Vicky said, before we take any questions at the end of this session, I'm going to briefly go through the principal remedies for breach of a restrictive covenant. At common law, the remedy is damages, but many benefiting owners may seek to prevent a breach by way of an injunction. And injunctions are granted at the discretion of the court. If you're applying for an injunction, the court generally expects the applicant to act quickly. In the 1998 case of Gafford and Graham, the Court of Appeal refused to grant an injunction to demolish a building which had been built in breach of a restrictive covenant. The court found that the applicants were clearly aware of the building work going on. They watched it happen. They watched the building being put up, but then they waited until weeks after the works had been completed before raising any objection. And the court felt that the injunction was therefore not appropriate. The court also has jurisdiction to award damages in lieu of an injunction where the injury to the claimant's rights is small, the value of the injury can be calculated in monetary terms, and the compensation itself will be small, and it would also be oppressive to grant an injunction. Damages for breach of covenant are calculated on the basis of the sum that would be reached in negotiations between the parties for the relaxation of the covenant, if each is making reasonable use of their respective bargaining positions, but also without holding out for unreasonable amounts. The amount of damages is ultimately a decision for the court to make, so it is important to carefully consider the likely measure of damages and therefore the proportionality of taking a matter to court. Thank you very much for joining us this morning, and have a great rest of your day, and we'll see you for the next one.